Good evening, everyone. My name is Caitlin Curry. I'm the Vice Chair of the Utah chapter of Backcountry Hunters and Anglers, who is tonight's host for Stewards on Stage. BHA is a grassroots North American conservation organization that acts as the sportsman's voice for public lands, public waters, and wildlife. BHA is engaged in these issues across our country and locally here in Utah through involvement with the Division of Wildlife Resources public process, through engagement with the state legislature and federal and state agencies. Our Utah chapter is entirely comprised of volunteers who are passionate hunters and anglers that strive to conserve our wild places and protect our way of life through policy and stewardship work. And I encourage you to learn more about our organization at backcountryhunters.org. I want to thank you all for joining us here tonight for this important conversation around public lands and the law. This topic could not be addressed at a more critical time. With each passing day, the value of our public lands grows, and so do the threats to their existence. Our federal public land system is a uniquely American concept. These lands are owned by and managed for the American people. On these lands, it doesn't matter where you come from or how much money you have. Access is for all. Public lands are the foundation upon which our hunting heritage is built as we know it, and it's our duty as sportsmen and women to protect them for future generations. Tonight's conversation focuses on a high-stakes issue that could fundamentally change these landscapes across the West forever, an issue that has emerged from right here in Utah. We're joined tonight by a very special guest to help us understand the complexities surrounding Utah's recent legal action with the Supreme Court that attempts to transfer federal lands to state management. I'm honored to introduce our guest speaker for this evening, John Ruple. John is a research professor of law at the University of Utah's S.J. Quinney College of Law and director of Law and Policy Program at the college's Wallace Stegner Center for Land Resources and the Environment. He returned to the University of Utah after serving as senior counsel in the White House Council on Environmental Quality during the Biden administration. And John has extensive experience working in federal land management agencies and government, private law firms, Governor John Huntsman Jr.'s Public Lands Office, and academia. He is widely published on various topics, including schemes to wrest control over public lands from the federal government, and the legality of efforts to reduce the Bears Ears and Grand Staircase Escalante National Monuments. Outside of his profession, he's an avid outdoorsman, passionate angler, and public land owner, like all of us. Tonight's conversation will be moderated by past chair of the Utah chapter of BHA and longtime public lands advocate, Joshua Lenart. We'll be having a Q&A period following the discussion, so please be respectful and concise with your questions and comments. We are live streaming this discussion on YouTube and Facebook, so please keep the background noise to a minimum. And without further ado, welcome to John and Joshua.
All right. Well, thank you so much, Caitlin. Thank you all for coming out today, especially those online that are joining us. For this live stream. I think this is Utah chapter's first official live stream, so I'm glad to be a part of it. John, to get started today, I was trying to think about the first time we met, and I think it was around 10, 11 years ago when Utah's first lawsuit, it was in response to the Transfer of Public Lands Act in 2012, and you and I got together at that time with a few other BHA members, and I thought, wow, what an asset people have in you and in fighting for public lands. And so, fast forward 10 years to August when Utah's more recent lawsuit came out, the board got together, we were scratching our heads and thought, boy, who do we get to talk about this? And you were the first name to come to mind because in every conversation I've heard about public lands prior to tonight, people always put this caveat out there like, oh, I'm no legal expert. And then they sort of go on their spiel. And so the fact that we have a legal expert in the room is really exciting. Maybe to get started, you can tell us a little bit about how you enjoy public lands and enjoy recreating on public lands, and then how you got involved in this niche area of law involving public lands.
Sure. Thanks, Josh. Before I get going, I really want to start by thanking all of you here. Special thanks to Caitlin, to Katie for doing all the logistical work, making this happen, to Josh for for hosting and his efforts, and really to all of you for being advocates for our public lands. It's incredibly important. BHA is a fantastic organization, and I'm really honored to be here and talk with you and have this conversation. So thank you very much. Thank you for what you do as stewards and advocates for our public lands. The buildup is a little intimidating, right? Because to say I'm a legal expert on this is kind of scary, because some of the state's arguments, I'll charitably call them novel. So since they're untested, in some ways there aren't a lot of experts, because this is all new ground, or maybe we're retilling 200-year-old ground that wasn't clearly articulated at the time. But I'll do my best. Before I kick it off, I do need to have a disclaimer. I am a state employee, but I am here in my personal capacity. I am not speaking on behalf of the state, the university, the College of Law, or anyone else. So as you might anticipate, I can be fairly critical of some of the arguments the state is making, and I am certainly not speaking on behalf or limiting their arguments or claims. Yeah, how did I come to public lands? Geez, I grew up in the West. I grew up outside of Seattle, and it's where we went. It's where we played. It's what we did. Hiking, biking, skiing, hunting, fishing. It was normal. And, it's the place for solace. It's the place for rejuvenation. And I feel really fortunate to be here in Utah, in a place where we have access to such amazing lands and such amazing resources and such diverse resources. So, it's really, really a pleasure to be here.
Nice. And maybe how did you get involved in the legal side of public lands? Obviously, when somebody asked me when I moved to Utah, my response is I wasn't born here, but I got here as quick as I could. But how did you transition from your interest and passion in the outdoors to more in line with your career trajectory?
Totally by chance. Like a lot of people, I went to college not knowing what I wanted to do, and I graduated from college not knowing what I wanted to do. So I went overseas and did relief work for a while, and came back and was a ski bum for a while, and was a ranger for the Forest Service, and ran a prison crew for a while, and realized that kind of being a vagabond and living out of your truck is cool for a little while, but I wanted a little more stability. So I went back to grad school, graduated, and then moved to Colorado. I went to work for an engineering company that was doing environmental permitting and design work for ski areas. So I did permitting for ski areas all over the western U.S. for the next 4 years. And it was fascinating. I got to be that liaison between the regulatory agencies and the Forest Service and the proponents and the public, and get, I think, a really unique insight into the way decisions are made. And along the way, I realized, you get in the red zone, you're down to the 5-yard line. That's when the lawyers always show up. And it seemed like they were the people that got us to a decision, that got it to the point, whether it was go or no go, they were the people that pushed it over the finish line. And I thought, I want to be able to do that. I'm tired of getting it down, going 95 yards and then turning it over to somebody else. So I went to law school figuring I would be a better bureaucrat. Zero interest in being a litigator. I think litigation in many cases, and particularly when we talk about public lands, it's the wrong tool. It's a blunt tool. It's a hammer when we need a very delicate instrument. So I thought I'd be a better bureaucrat, graduated into a federal hiring freeze, and ended up in private litigation. And, life is what it is. So I learned a lot. Had the opportunity to come back to Utah and work under Governor Huntsman in his public lands office. He's a brilliant, thoughtful, and I think really intellectually curious individual. I really appreciate that opportunity. Bounce forward, I had the opportunity to come up to the university, and I've been here ever since in one way, shape, or form, and had the privilege of serving 2 years in the Biden administration, and now I'm back, just poking away at public lands.
Seems like you came back at a good time. We're happy to have you. I don't know. Let's take the bull by the horns on this one. Maybe you can, I know most of the folks in this room are probably pretty familiar with the lawsuit, but maybe for the folks joining us online that aren't in Utah but have an interest in public lands, maybe if you could start with the 2012 Utah Transfer of Public Lands Act and talk to a little bit about what that act was, and then the legal the legal lawsuit that ultimately followed, and then maybe bring us up to speed on how that is similar or dissimilar to Utah's more current lawsuit, and maybe talk us through that a little bit.
Sure. So Utah has always been kind of a hotbed for discussions over the fate and the management of federal public lands. The Sagebrush Rebellion, all of that stuff. And back in 2012, a handful of legislators got together and they passed the Transfer of Public Lands Act. I shouldn't say a handful, it was a majority of them, right? So the Transfer of Public Lands Act basically wagged a finger at the federal government and said, we demand that you, federal government, convey all right and title to federal public lands to us, the state of Utah. It was about 31.5 million acres of land at that time, and they said, if you fail to do so, we're going to sue you. And the federal government, not surprisingly, looked at that and said, okay, sue away. You know, we think we're on pretty strong legal grounds here. And Utah never filed suit. So it just kind of withered on the vine. I believe the legislature at that time had set aside something like $14 million to pay for litigation, but I'm not sure whatever happened at it. I think it sat until today. So the basis of that suit, or the Transfer of Public Lands Act, the law demanded that the federal government turn over that land to the state, but it never really articulated the good, clear reason why Utah deserved it. So we did some work on it, we responded to it, but it was kind of a lot like, well, what arguments could they be making? What is the rationale behind this? And a lot of those arguments we see today. We can talk about the property clause and the word disposal. We can talk about disclaimers. I'm sure we'll talk about the equal footing doctrine. So we see a lot of the same themes coming through, but over the years, the state has kind of honed its argument. And what they're saying today in the lawsuit they filed, a couple months ago, I guess, in the the U.S. Supreme Court, is that the Constitution of the United States, it grants Congress the exclusive power to control federal public lands. But there's only one thing Congress can do under that power, and it's to dispose of unappropriated federal public lands. Kind of dig into what each one of those terms means. So that's the essence of the argument. They talk a little bit about some of this equal footing doctrine stuff, but it's essentially the property clause of the U.S. Constitution. And what the property clause says, I'm paraphrasing because I don't think I can quote it quite right here, is that Congress has the authority to dispose of and make all needful rules and regulations regarding federal property and land. So something very, very close to that. And Utah's argument is essentially dispose. All that Congress can do is dispose of public lands. Okay, so it has some appeal on its face, but there's some really big problems in there. The first one I want to poke at is the definition of dispose. When we think of dispose, we think of throwing away. We think getting rid of something. But if you open up the dictionary, there are a number of other definitions in there, and there are definitions that go back to the time of the founding of our republic to the creation of the Constitution. And they talk about disposal as being management. They talk about disposal being organization. They talk about it in terms of military commanders disposing of their troops in ranks on the field of battle. They talk about it in terms of disposing trees in an orderly fashion in a garden. they talk about it in ways that have nothing to do with throwing away or getting rid of valuable resources. And the state completely ignores that. They pick one definition, they hold on to that, and they haven't addressed any of the other definitions that exist at the time the Constitution was drafted and that were in existence at the time Utah became a state. So that's a big problem. The Property Clause also says that Congress can make regulations regarding the territorial property of the United States, and that's what they have done in enacting laws like FLPMA, the Federal Land Policy and Management Act, in enacting laws like NIFMA, the National Forest Management Act, that set up requirements for multiple use, sustained yield, and kind of a balanced approach to land management. So I think we've done that, and we can talk more about that. Why don't I stop there?
Yeah. Well, maybe one more. You mentioned the equal footing doctrine. Maybe you can talk about that before we kind of move past this point.
Okay. So the equal footing doctrine. Back in the day, sorry for the history lesson, I apologize, but we're having to go back into history to understand some of these claims. They're really history laden. During the Revolutionary War, Georgia was one of the original 13 colonies. At the end of the war, the treaty with Britain that ended hostilities recognized each of those 13 states as individual sovereigns. There was no United States at that point. There were 13 states acting together. So title to land went from Great Britain to Georgia. Georgia, like the other states, said, hey, we're going to give some of our land to the federal government. There were huge battles about ownership and control of the western frontier, and the idea was we're going to give this to the federal government. One, the government can then use it to pay off war debt, and two, they will handle kind of the organization, disposal of this landscape in ways that are fair to the Union. So Georgia gives the land to the federal government then creates Alabama. And you end up with a title dispute, a dispute over who owns a piece of land in this newly created state of Alabama. And it involves lands that are submerged underneath the water. And one side says, well, we acquired our title from the state of Alabama, we win. The other side says, we got ours from the federal government, we win. And what the Supreme Court said is that when Georgia acquired title to that land, they gained everything. The land, the subsurface minerals, all of those rights. When they surrendered those to the federal government, it was with the expectation that every newly admitted state would come in with the same rights as Georgia and the other 12 other original colonies. So because of that, the Supreme Court said, Alabama, you have the superior claim of title to these submerged lands because under the equal footing doctrine, you come in with the same political rights and the same political sovereignty as every other state. And the only way to do that is to give you the ability to address title over these lands, okay? So a couple of really important caveats to this. One, this is 1845, so we're talking about a case before the Civil War was fought. More importantly, the Supreme Court has revisited the equal footing doctrine over the years. And they've said a couple of really important things. I think the most important thing is it only applies to submerged lands. It has never, by any court that I know of, been extended to dry land. The second point, which is probably even more important, is that the equal footing doctrine is about political rights and sovereignty. It is not about equality of condition. And the Supreme Court has been clear, they've repeatedly explained this, that it means that a newly created state, when it comes in, it's entitled to the same kinds of representation in Congress, the same 2 senators as every other state. It's entitled to apportionment in the House of Representatives based on the same formula. It's entitled to the same rights and the same protections and the same responsibilities under our Constitution. But what it doesn't do is force the federal government to somehow create equality of conditions. The Supreme Court has long recognized that Kansas is not Utah. We are never going to have their irrigable lands, and they're never going to have our mountains. It's not the government's job to equate those conditions. It's to make sure that we as citizens have equal rights. So to say the equal footing doctrine somehow forces the federal government to dispose of or give away or whatever that means, lands in Utah to make them more like Eastern lands, it just doesn't work. Back in 2012, as Josh said, we had the Transfer of Public Lands Act. We started doing work on that about 2 years later. There was an opinion that came out. We did a bunch of work at the Stegner Center. The Conference of Western Attorneys General, which is a fairly conservative group of attorney generals from across the Western U.S., I think 12 out of 13 of their members said that the equal footing doctrine had no relevance to the state's claims. So there's pretty strong consensus on that point. And maybe to back up a little bit here, it's important to really distinguish the East from the West. And I'm going to kind of use the Mississippi River as the dividing line. So at the end of the Revolutionary War, Great Britain surrendered title to lands to the original 13 states, right? And we had some battles over who owns what and where, but essentially you had 13 separate sovereigns claiming title to the land from the Atlantic Ocean west to the Mississippi River. They gave up land to the federal government. So there was no federal land east of the Mississippi until, at least within the area that was part of those original 13 states, until those states created a federal government and gave it land. Jump west. Very different situation in the western U.S. and parts of the South, right? The U.S. went out and acquired those lands. The federal government did. You think of the Louisiana Purchase, the purchase of Alaska. You think of the Mexican-American War. Those at the Louisiana Purchase, the Alaska Purchase, that was federal money. The Treaty of Guadalupe Hidalgo that ended the Mexican-American War, that involved a payment of resources from the federal government to Mexico, plus the expenditure of lives and federal military force. So those lands, they come into the Union not as states, they're federal territory. They've been acquired with federal blood, federal treasure. They belong to us as a nation. They've been purchased by every American. And then the federal government goes out and starts creating states. So in Utah's case, this was 1846 or something. We end the Mexican-American Wars. 2 years later, that the federal government grants territorial status to the state of Utah. So it comes in as a federal territory, not as a state. We still have no state of Utah at this point. And they come in as a territory, and I think it was another 46 years later, something like that, we eventually become a state. The process there was the federal government enacted a law, the Enabling Act, that set forth the conditions that the residents of the territory of Utah had to meet in order to become a state. So we took 7 shots at it before we got it right, drafted constitutions, submitted those to the voters within the territory. When they finally approved the constitution that met the requirements set forth by Congress, Congress passed a law, invited Utah into the Union as a state. So when we're thinking of the West, it's federal until it becomes state. When we're thinking East, it's state land before it becomes federal. And I think that's a really important distinction. And it's important to remember when some people say this is about taking back our lands, that's just legally and factually wrong. Now, title to the lands we're on today, it originally vested in the Native Americans that call this land home. They hold what the law considers aboriginal title to this landscape. They lost it. They lost it under another legal doctrine, the doctrine of conquest, when the Spaniards came in and steamrolled the West and seized this landscape. Spaniards held it until Mexico won its independence from Spain. Mexico held it until the end of the Mexican-American War when the federal government stepped in. So there's simply, Utah didn't come into the chain of title until after it became a state. At that point, there was a bargain. The federal government recognized that it's really expensive to be a new state. It's hard. We want to support you. We want to help you as a state have the resources to succeed. We're cash poor, land rich. We don't have a federal income tax at that point. So the federal government hands over land to the state of Utah. It's about 7.5 million acres of land. Some of that was in designated blocks that could then be used to build a capital, to do very specific things. A lot of it was scattered across the landscape. But the important part is the federal government gave that 7.5 million acres of land to Utah. That's what we think of now as trust lands, or sometimes SITLA lands, even though they've changed their names. And in return for that, Utah had to make a concession. Utah had to agree to disclaim all future right and title to unappropriated public lands within the state of Utah. That was a condition of us becoming a state. And not only did we have to agree to it, we had to incorporate it into our state constitution. We had to incorporate it, and we had to say not only is it part of our constitution, but it's unrevocable without the consent of the federal government. So when people talk about Utah's rights or forcing the federal government to give away land, I think it's really important to remember that the federal constitution grants the power over public lands to Congress. Utah has disclaimed title to lands beyond the 7.5 million acres we already received. So Utah doesn't necessarily have a right. We've already kind of said it's not going to be ours. And that's really important because when you read the Bill of Complaint, Utah's document that went up to the Supreme Court, they're not saying, federal government, you give Utah 18.5 million acres of land. I think this is a really important point that the media hasn't fully picked up on. What the state is saying to the federal government is that federal government, it is unconstitutional for you to continue to hold unappropriated federal lands. You must dispose of those. And by dispose, I mean convey away title. Doesn't mean that title has to go to the state of Utah. It doesn't mean title necessarily conveys for free. It just says, federal government, you can no longer hold these lands. So think about that for a minute. If the federal government truly is obligated to end title to these lands, to convey away the title to what we think of as BLM managed public lands, how would they do that? Who would that land go to? Under what terms? Who decides? I think there's a pretty powerful argument to be made that since that land was acquired by all Americans deserve some share in the benefits of if that land is conveyed away. So maybe it shouldn't be given away. Maybe it should be sold at the highest bidder in order to pay down our national debt. I'm not saying that that's the option I prefer, but I think there's a reasonable argument to be made there. Where does that leave Utah? So is Utah then in a bidding war against George Soros to buy lands in Utah? With Ted Turner? With somebody that wants to create that multi-million-dollar ranch that they will then fence and keep out the public? I mean, it's a fair question. Maybe that land goes to a hedge fund that's their focus is simply to generate as much money as quickly as they can, and then they turn it around and lease that land for oil and gas development or whatever that may be. Maybe it's oil and gas developers that buy it. We don't know. I mean, if you want a really scary scenario, one that should probably get all of you inflamed, what if California and Arizona get together and they say, you know what? We'd like some water. There are lands out there that are now for sale that have water rights on them for maybe for agriculture, maybe they have it for livestock grazing, maybe they're, whatever that might be. We're going to acquire those lands, acquire those water rights, and then we're going to try and move that water downstream to Arizona or California. I don't want to say it's an absurd scenario, but I think it's safe to say we would be litigating that for decades to come. And those are the kinds of problems that I think we really have to be ready for when we think about conveying title of federal public lands out of federal hands. Who would get it? How would they get it? And one other wrinkle, I know I'm rambling here, but one other wrinkle just to complicate this more, as lawyers, we think of rights in land is complicated. We talk about it as a bundle of sticks. We distinguish between the right to the surface from the rights to the minerals underneath. We distinguish rights in land from rights in water that flows across land. We go down to that mineral estate and we may divide that up a dozen different ways to include coal, oil, natural gas, uranium, a bunch of other things. So all of those pieces, all of those estates can be conveyed away separately. Utah seems to be assuming not only that they will magically get this land, but when they receive it, well, they'll receive it for free and they're going to get the minerals underneath. I think those are three massive untested assumptions. And history as well as law shows us where the federal government has done exactly the opposite. Right? We have a long history of the federal government conveying away millions of acres of land, whether it was to homesteaders, whether it was grants to states, whether it was grants to railroads, whether it was grants to miners. Oftentimes, the federal government, especially in the case of homesteads, they said, yes, you can have the surface, maybe for free, maybe for a minimal cost, but we're going to keep the minerals. That is a massive piece of what federal land disposal has been historically. And I think it's really important to think about that and say, if the Supreme Court was to say, feds, you have to give up this land, not only who, when, how, for what cost, and then who gets the benefits from that, but is it the surface? Is it the subsurface? Is it some combination of both? How do we unpack if those unreserved lands already have leases for cattle grazing, if they already have leases for oil and gas, if they have mining claims under the 1872 mining law? I say this because we don't have answers to this. It's simply unknown. The one thing I can say with absolute confidence is if the state wins and the Supreme Court was to say, federal government, you've got to surrender title to lands in Utah, 18.5 million acres of land. So I think two things are certain. One, you're going to see every other state in the West or somebody from every other state in the West jumping on the bandwagon and making similar claims. And the other thing you're going to see is decades of litigation to try and resolve all of these thorny questions. Who gets the proceeds? How are these lands given away? Under what conditions? To whom? And what rights do they get? What happens to those lands that are already encumbered by a grazing lease or a timber lease or an oil and gas lease? What happens if there's a 50-year-old mining claim on that land? What happens if that land has a water right associated with it? All of those things are going to have to be sorted out. And if you're into full employment for lawyers, great. But, personally, I think this is really a terrible idea.
John, I have like 5 threads I'm trying to
I ramble, sorry.
Well,
get me fired up.
I want to keep them all straight, but maybe we'll start with the point you left off on, and then I'll try to go back, because I think you said a few things that are really important to understand for me personally, but I think for people in general. So thinking about Utah's most recent lawsuit, they're claiming that the U.S. government can't own the land, but they're not claiming that they they necessarily have the ownership. So do you think they've
Correct.
thought through this, past this argument of just assuming Supreme Court votes in our favor, and lo and behold, it comes back to us? But that's not like the cause and effect that you're describing. So can you put yourself in the state's shoes in that regard and kind of talk me through like their game plan for should the Supreme Court decide in their favor?
Again, I don't speak for the state. I have no particular insight into their legal theories. I have no discussion with the Attorney General's office or their outside counsel. So I don't know. All I can do is speculate. I think what I would say is that a lot of these issues have been raised before. This isn't new. The state is, or at least absolutely should be aware of everything I've said already. I think it's also safe to say the state has some very good lawyers, both in the Office of the Attorney General, in the Office of Legislative Counsel, and as outside counsel. Paul Clement, the gentleman that is representing the state in front of the U.S. Supreme Court, he is one of the best Supreme Court litigators of all time. He has a tremendous record. He's a former U.S. Solicitor General. He's brilliant. That's why we're paying him $2,300 an hour. They must have thought about this. What the end game is, I can't speculate to that. Maybe they think, maybe they're relying on the incoming administration and thinking there will be some kind of settlement that can be reached. Maybe they are thinking that, if the Supreme Court rules in their favor, that will open up a floodgate and Congress will have to act. Maybe they are thinking that this is the kind of issue that really motivates people, that really creates fire in the belly and inspires a political base that feels disenfranchised. So I don't know what their end game is. And to me, that's one of the most troubling aspects of this, right? The implications are unclear and they are so big. As a baby lawyer, as a law student, I was taught that good lawyering is about being really careful, really meticulous, really precise. That a good judge is going to be so cautious. They are not going to want to rule more broadly than they absolutely have to. They're going to try and keep their opinion as narrow as humanly possible because they don't want unintended consequences. And, kind of that judicial restraint, it's been a hallmark of, I think, legal education and legal reasoning for a long time. And the state's arguments, they're just the opposite of that. They're scorched earth. And that's alarming because we just don't know the implications.
So do you think, it sort of begs the question, do you think the Supreme Court will even hear Utah's case? I know just a couple days ago, Utah Dispatch News had a quote from the Attorney General's General Counsel, and he seems to think we might be hearing as soon as January. Do you think that's a viable possibility, or maybe it goes unnoticed and we don't even have to worry about it because the Supreme Court's not going to touch it?
That's a great question, Josh. And there's a little bit to unpack there, right? Normally, if somebody files a lawsuit in federal court, they go to the district court or the trial judge. You have a trial. The judge figures out in the jury. They figure out what the facts are. They figure out what law applies. They apply a lot of the facts. You get a decision. If you don't like the decision, you appeal it up to one of the circuit courts of appeal. If you don't like that, then you can go to the U.S. Supreme Court. But the Supreme Court is not under any obligation to hear your case. You submit a petition, and if you're in that lucky 1% to 2%, they agree to hear your case. 97, 98% of the time, they do not grant cert. So Utah is trying to jump the queue. They did not file in a district court. They went straight to the U.S. Supreme Court under what's called original jurisdiction. And they say that, there are a certain class of lawsuits between states, lawsuits between, a state and an ambassador, lawsuits by a state against the federal government, where you can go straight to the U.S. Supreme Court. But again, the Supreme Court is under no obligation to take this case. What they will consider the process for determining whether to take up the case, I don't know. It's a bit of a black box. I think to kind of pick up on that judicial restraint argument, I think there's a good argument to say the Supreme Court should not accept this case. They should say, Utah, there's no reason to go to the Supreme Court. There are important issues of law, there are important issues of fact that need to be resolved. The best place to do that is in the district court. They are the finders of fact. And they can sort out some of those thorny issues I was talking about or rambling about a few minutes ago. That's going to be the place to hear it. Let that case percolate up through the Court of Appeals, let them rule, and then we as an appellate body, we can issue an opinion. So I think the wise course of action would be for the Supreme Court to say, no, we're not going to take it. And I think that is most likely what they will do. That said, I'm reading tea leaves on that, and I don't know. I don't know what they're going to say. And I also don't know what the state would do if the Supreme Court says, we want this to begin down in the district court. The state has said they will immediately file suit in federal district court. I assume that would be federal district court here in Utah. Whether they do so or not, we'll see. But either way, you're ready for years of litigation. I don't know if that answered the question.
Yeah, I think you acknowledged that nobody really has the answer to that. I did read also the Department of Justice came out with a brief in response to Utah's lawsuit. Among other points, they say that the suit is without merit and untimely. Based on, well, first off, do we have a friend in the Department of Justice as public landowners? It feels like we do. Go ahead.
Yeah, I think it's safe to say
Are they all closet public landowners?
I think they are all public landowners. They are all taxpayers. And the thing about the Department of Justice is the lawyers in the Department of Justice, in the solicitor's office, they truly are the best of the best. They are incredibly good lawyers, and they're not ideologues. They are going to focus on the rule of law. And I think that's important. I think they understand the implications of this case, and they have pushed back aggressively. If you read the state or the Department of Justice's response, as Josh said, they point out a lot of problems. One, there's this doctrine of sovereign immunity that you can't sue the federal government unless the federal government agrees to be sued. It hasn't. There's another problem that normally there's a statute of limitations on claims, and normally that's 6 years. The Department of Justice points out that it's not clear when that runs from. If it's from Utah statehood, we're well beyond 6 years. If it's 1976, an enactment of FLPMA, the Federal Land Policy and Management Act, that created this federal policy against further disposal of federal lands. Again, you're 40-some years in. It's hard to imagine why the state's claim would be timely. There are a number of other issues as well. I think that the Department of Justice has pushed back aggressively. I'm hopeful that the court will listen to those concerns, but we won't know until the Supreme Court rules.
So I noticed also in that DOJ brief, it pointed out that the FLPMA, that so much of BLM management hinges upon, never actually used the term unappropriated in that original rule. And so, I don't know, it seems like a lot hinges on this word between appropriated and unappropriated. Like, why has Utah picked up on it? Does it have historical context? And can we magically appropriate the land? I mean, why don't we just appropriate it before the current administration leaves office, right? I mean, maybe talk us through those two differentiations.
Okay. So I started off with a bit of a rant about what does dispose mean. Now I'm going to have a bit of a rant about what unappropriated means. Because Josh, you're right. FLTMA doesn't talk about unappropriated lands. The state's complaint says that the federal government is required to dispose of unappropriated public lands, but it doesn't say what constitutes an appropriation, who made those appropriations, under what authority, or how broad they are. The state includes some disclaimers and says, oh, no, we're not interested in national parks. We're not interested in national monuments. Those lands have been appropriated. Okay. But their argument is based on the constitutionality of retaining ownership, regardless of whether it was appropriated or unappropriated. It is the state's choice to limit their claims to 18.5 million acres. They could just as easily, just as credibly be claiming title to lands within national parks, within national monuments, within national forests. Basically everything, at least by my read, everything short of military installations.
And in fact, in 2012, it was 31 million.
Right,
acres.
it was 31.5 million there. So they've good news, they've ratcheted back. Bad news, we don't know why. I mean, it's good that they've kind of peeled back a bit, but again, that is their own restraint. If there is an obligation to convey away title, arguably the next case we're going to have is it just to unappropriated lands? Is it to all public lands? I mean, it follows way too easily from there. Yeah, I think I'll stop there.
Yeah, well, I think for me it raises a question about and I think for most people here tonight, the precedent for other states in response. One question I had when you were talking about the Treaty of Guadalupe Hidalgo, why did a state like Texas, why were they able to retain so much of their land as private when Utah was only given these 7 million acres? Maybe you can talk about how that treaty worked differently for these two states, because it seems like states today, like Texas, who filed a Friends of the Court brief in support of Utah's recent lawsuit, has a vested interest in Utah. And I guess I don't understand what a state like Texas's interest in Utah public lands is, or public land in general. So maybe differentiate between Utah and Texas at statehood then, and what that means for states now, should the Supreme Court side in favor of Utah.
Okay. Texas.
Sorry.
Texas is different. Texas is special, right? Texas came in as a republic, the Republic of Texas, kind of as its own independent entity. And Texas is Texas. I'm not going to pretend to know a whole lot about it. I'm sorry if anyone live streaming is from Texas. I should be kinder. I'm sure it's a lovely state. But it came in a different capacity. It came in as a republic that was recognized as having its own level of sovereignty and therefore controlling the land within its borders. So it didn't come in as federal territory and then the federal government then gave land back to the state. At least that's my understanding. But thinking about other states, and Josh, I'm glad you brought up other states, because to my earlier point, Wyoming submitted an amicus brief, a friend of the court brief in support of the state of Utah's claim before the U.S. Supreme Court, and they said the quiet part out loud. They said it's show my nerdiness. It's in footnote 3. They say that they don't believe the claims should be limited to unappropriated public lands. They say flat out, the federal government should be required to convey away title to all public lands that are outside of what's called a federal enclave. And we don't need to get into the deep nerdiness of what that means, but basically think other than Washington, D.C. and military bases that have been purchased. I mean, it's a good word, but stepping back, Utah is not like a lot of other states. We have a lot of federal public land here. About 2/3 of the land in the state is under federal control. And that's different. If you go into California or Oregon or Washington or Idaho, you see a smaller number. And it's a reflection of physical reality. If you go back and you think 1845, what was life like? It was hard. It was rugged. People moved into places where they could grow crops, where they could make a living. You couldn't go to Walmart if you ran out of food. You needed to homestead in places where you had irrigable land that likely wouldn't flood every spring. And Utah's pretty rugged, right? Outside of a lot of river valleys, there are places it would be really hard to live. So that makes us different than Kansas. That makes us different than the east slope of Colorado. There isn't a lot of public land in those places because homesteaders looked at it and they said, yeah, we can make a home here. There aren't a whole lot of people that looked out at the West Desert and said, that's really inviting. So the fact that a lot of this land remained in federal ownership, it's just a reflection of geography, of climate, of precipitation, of growing seasons, and of the reality of being a settler. The other thing, to go back to the earlier point about unappropriated public lands. Again, we don't know what that term unappropriated means. The state, in its brief, they've said they are not going after national parks. They're not going after national monuments. Again, that's self-limiting. But there are a lot of other things out there that could be considered an appropriation. The presidents have for a long time set aside lands as forest reserves, what we now think of as national forests. Is that an appropriation? Well, what about grazing districts? The Taylor Grazing Act of 1934 set up grazing districts, and it set up a default that once a grazing district is created, it is presumptively withdrawn until it's released. Is that withdrawal the same as a reservation? The president then said, whoa, Taylor Grazing Act, that wasn't enough. My 20 million acres of withdrawals there, that wasn't enough. We're coming out of the Dust Bowl. We're concerned about how lands are being managed. We, as a nation, or through the Secretary of Interior's office, are going to withdraw all unappropriated public lands from disposal until they are classified, until we've figured out how best to use those lands. Some of those have been released. A lot of them haven't. Is that withdrawal and appropriation within the meaning of the state's complaint? What about a forest plan or a BLM management plan? If they look at an area and say, this needs to be managed as critical winter range for ungulates, at a reservation or withdrawal, who decides? So again, I think that if you come away with one point, it's going to be the really dissatisfying one, that we don't have answers to these questions. And to me, that's the truly terrifying question. That's the truly terrifying part of the Utah lawsuit, is it opens up Pandora's box. It opens up all of these questions that we don't have any answers to. And to me, it's concerning, it's dangerous, and it invites litigation.
Yeah. I grew up hunting and fishing in the Midwest, and, when we were growing up, you just sort of walked everywhere, went anywhere. There was no trespassing signs. There was no, and, slowly, late 80s, 90s, more and more farmsteads and homesteads, they were either bought and developed or they were privatized. And so I think, from a hunting and fishing perspective, everybody here tonight is really concerned chiefly about access. Secondly, about disposal. The state's lawsuit says it won't sell or dispose of land except for rare exceptions. How much faith do you put in this state's perspective, given what we know about what it costs to manage these lands, what the federal government is subsidizing in terms of, grazing and payment in lieu of taxes and all of this? What do hunters and anglers really stand to lose the most, or do they? Are we being sort of the sky is falling, or is this as big of a threat that some of us think it is?
I think about the state's promise not to dispose of lands or not to sell off lands except in extraordinary circumstances. And the first point I'd make is that assumes they get the land in the first place. If the Supreme Court says, hey, you got to auction this off, and Congress says, hey, we want to have the revenue go back to the taxpayer, it's not Utah's call. But let's assume, just for sake of argument, that the Supreme Court says, feds, you've got to convey away title. You've got to convey away, and that in our mind means give to the state of Utah. I think that forks in two directions. One is the federal government gives up title to the surface. The other is the federal government gives up title to the surface and the minerals. Back in the 20s, there was an effort on the part of the federal government, and it was kind of state-driven at the time, to convince the federal government to convey away the rest of the public domain, to give that land to the states. And I think it was under Herbert Hoover, and he convened a commission and said, this is a pretty good idea. This is really expensive for the federal government to manage, so we are going to investigate turning this land over to the states. And there was legislation, it was prepared. I'm not sure if it was ever introduced into Congress, but it called for disposal of these lands. But it was only the land surface. And you know what the states said? No way. We need the minerals to make this pay. We can't manage the surface estate and pay the expenses, and cover our management expenses based on the surface alone. And that was almost 100 years ago. Things haven't changed. We live in a beautiful state, but you're not going to generate a lot of revenue grazing cattle. Just it doesn't produce the kind of revenue that we need to manage that landscape. So if you have a fire down in Milford, that's going to be expensive to fight. Are you going to be able to pay for that with grazing revenues? If your landscape is PJ, how many cows can you graze? What's your revenue source? That's not saw timber. Could the state generate enough money to cover its expenses? And I think until you tap into minerals, the answer is it's going to be difficult. Maybe I'm wrong. Maybe solar changes that. Maybe geothermal change. Well, geothermal then is that. Would the state have rights to that? But it gets pretty difficult. So if the state was to receive the mineral rights, then I tend to think the state's probably accurate in saying they're not going to sell a whole lot of land. Is that going to be a noticeable difference to you as a public land user? Are you going to notice that when you're out hunting, fishing, biking, whatever that is? Maybe not. If lands are developed for oil and gas, typically the federal government and SITLA, the State Trust Lands Administration, they lease the land. So they still own it, but the pump jacks, the derricks, the compressor stations, the pipelines, the road network, that impacts wildlife. That impacts our recreational experience. It's still federal land. Ownership hasn't changed. So the state can be completely accurate in saying, yeah, we're not going to sell it, but it may look very, very different to you.
We've been hammering away at this for about 50 minutes. I want to be sure we get to the audience for Q&A. And there's so many things we haven't talked about. Mike Lee's Houses Act, right? Do you think Mike Lee's Houses Act is a good idea? I mean, this idea that we sell certain less valuable parcels of BLM for low-income housing. Is it actually going to be a low-income housing? How does something like this lawsuit affect national monument designation? Everybody here in Utah has seen it with Grand Staircase and Bears Ears. It's gone back and forth, and it might be going back and forth again here shortly. Maybe if you can kind of, before we move into the Q&A section, what gives you hope, right? Like it's easy to sort of lose sight of the end goal And conversely, what keeps you up at night? What do you think best worst case scenario is as we're, facing this unknown when things are as tethered one to the next, as you've, I think, done a really great job of pointing out?
Okay, I want to touch on the Houses Act really quickly, or at least conceptually, right? So we've got Mike Lee and others that are proposing federal legislation that would authorize the sale of certain public lands to support residential development. The devil's in the details. I could potentially support that. I think there are communities that are constrained by federal lands where we have a desperate need for affordable housing. I think there are also parcels of land, particularly BLM land, that are very small, very isolated, and difficult to manage. They're actually urban BLM parcels. They don't provide public access to anglers or fishers, or you're never going to graze out in Eagle Mountain within a subdivision. If we can take those small parcels, half an acre, 2 acres, that are close to residential communities, that are close to the services, water, sewer, high-speed internet, whatever they are, we can move those into residential development, and not McMansions, but affordable housing. Maybe I'm okay with that. And maybe that revenue can then support better management of national forests. Maybe it helps us in managing wildlife refuges or other landscapes. So I think there's some opportunity there, but it really depends on the detail of that legislation. And we'll see where that goes. In terms of what keeps me up at night, other than the things that we've already talked about right now, is, endless litigation and uncertainty, which I think is bad for everybody, right? I'm an institutionalist. I just want clarity. I believe that if we have rules that are clearly defined, and there I mean laws, regulations, if we have people to implement those, and those people have the resources they need, hopefully we can get to a good outcome. That if you're a litigant in Louisiana, you should have the same rights and hopefully the same outcome as you'd have in California. I'm going to rein it back a bit here. When I think of hope, I think of the folks in this room. I think of people pushing on our legislators, on members of Congress to think carefully, to think rationally, to think through some of the implications of these decisions. I have my own feelings about how federal public land should be managed, where that balance of multiple use lies, how we balance resource extraction versus resource conservation. And reasonable people can disagree about that. But I think those aren't questions that belong in a court of law. Those are questions that belong in the halls of Congress, where you can have a rational debate, where you can have public hearing, where you can decide and weigh the various courses of action. That's not to say I am particularly comfortable with the composition of Congress right now, but I think it's a better place to have these kinds of policy debates and discussions than in court. So I guess what gives me hope is the people in this room, people that are paying attention, people that care about public lands, people that are going to engage in the democratic process. What scares me beyond what we've already talked about, a guy named Grover Norquist. You guys remember him? His goal was to shrink government down. I think his famous quote was, he wants to shrink it down to the point where you could drown it in the bathtub. That's right. And I fear that there is a lot of kind of Grover Norquist-esque vibe going on right now. And it scares me because we get the government we invest in. And I mean that regardless of where you sit on the political spectrum. It wasn't that long ago that a guy was able to take a shot at candidate Trump. And then less than a month later, another shooter is found in the edge of the golf course getting ready to take a shot at him. How in the world is that possible? How in the world do we fail to secure the perimeter around a presidential candidate, around a former president? How in the world is a guy within, 200 yards on a line of sight of Donald Trump? To me, that's a failure of government. And I don't mean that in a pejorative way. I mean the FBI and the Secret Service just don't have the people to do the job. If we're not investing in government, we need to be ready for the consequences of underinvestment. And I'd say the same thing about our national forests. If you're unhappy with the condition of our national forests, then we need to do something about that. And I don't know if you all noticed, but a couple months ago, the Forest Service came out and made an announcement. We said, no more seasonal hires. Can't afford it. No more hires except for fire. And we are only going to promote internally because we can't go out and backfill all of these empty positions. That's a recipe for disaster. If we don't have people in government to do the work of government, we need to be ready for the consequences. If the Forest Service doesn't have seasonal employees, they're not going to be out there maintaining trails. They're not going to be out there maintaining campgrounds. They're not going to be out there doing timber stand improvement and wildlife habitat improvement. They're not going to be out there burning the slash piles near my house, right? They're not going to be doing the prescribed burns to manage that landscape. And then we're all going to suffer. So the nightmare scenario for me is starving government, underinvesting in government, and denying people the resources they need to do their job, right? If I do a lot of work on permitting, and got to have butts in seats in order to process permit applications. It's as simple as that. Doesn't matter whether you're an oil and gas operator or a solar or wind energy developer. If you don't have the wildlife biologists in there to look at those permit applications, to consider, what needs to be done, it's going to get stuck. And, anyway, that's my rant.
No, that's great. I think that's a great note to transition to the audience on. If there's any questions, I'd like to open it up a bit, see if there's some themes that we can go back to. I'm sure there are. So, yeah, please.
Thank you. Could you speak to budget management? Like you said, if Utah were to get the surface and mineral rights, that maybe that could work. Could you speak to existing budget management of BLM lands? Obviously, the BLM is national, so if there's a bunch of fires in Utah one year, maybe they can pull resources that they're getting from other areas. But is it okay to assume that inherently Utah's BLM land is self-sustaining right now to the BLM's budget as it's segmented, or is that not safe to assume? Because I've heard differing things about that, especially on the fire side. Like fire money comes federally, and it's impossible to manage that in a localized way.
It's a great question. I haven't seen any current numbers. Paul Jackas, who is at Utah State, he did a big report, I think in 2018 on this, and a couple of takeaways. He said, first of all, this argument that state employees are inherently more efficient than federal employees, not true. There's nothing magical about state employees, and I apologize if there's state employees in the room. You're great. It means you're incredibly valuable, but that's nothing magical. The difference is in the mandate they operate under. I think your point about fire is very well taken. What burns in Utah changes year to year. We've had years where very little burn. We've had years where it's a lot. Presumably, if lands were conveyed to the state of Utah, Utah would have the responsibility for managing those lands. That would include fire suppression. That could be an astronomical cost in bad years. I mean, I imagine what would happen if Emigration Canyon burned. I was here a couple years ago. I remember there was a fire along I-80. A catalytic converter burst, and it started a fire that ran up towards Summit Park. And I remember driving down I-80 shortly after that happened, and it was absolutely awe-inspiring. The response was insane. I'd never seen like the DC-10s when they convert them into fire suppression planes and are doing retardant drops. That was cool to see a plane that big, like 150 feet off the deck, right over the interstate. That was the real deal. And they had multiple. They were staged. You had these helicopters. It was like a Congo line of helicopters doing water drops. Those are big resources. I don't know that the state of Utah has that. And I think about what that means dollar-wise. If those kinds of big events occur early, those expenses occur early. We may not have that stockpile of revenue to work from. And that's a problem because we also have a balanced budget requirement written into state law. So what does that mean? All of a sudden, we've got that fire in Emigration Canyon. We've got it in Parleys. We spend hundreds of millions, or we get a huge conflagration up in Uintas. We spend millions, tens of millions, hundreds of millions responding to these fires all over the state. Where's the money come from? If we have to balance the budget, it seems like we've got two options. One is to increase revenue, which means increase taxes. The other is to cut expenses. What are we going to do? We're 49th in the nation in per pupil spending. I don't think we're going to get it out of education. So I had to throw that dig in there. So, yeah, it's a fair question. And I don't think we know. I think it's safe to assume that short of minerals, most BLM managed public lands do not generate sufficient revenue to cover their management costs. They're subsidized by taxpayers and by other uses, by oil, gas, minerals, mining, and so forth.
Thank you. Real quick, while I have my time, I want to quickly address the audience and say that in the scenario where Utah does acquire these lands, I had the fortunate opportunity to work for the Utah DWR, which manages tens of thousands of acres throughout the state. I was one of 4 people assigned to the northern region for the maintenance of all of those acres in that region. So we already don't have enough for what we have. But my question is, going back to the appropriation question, is there any legal precedent that says the ecosystem services are a form of appropriation? And would this be the opportunity to set that precedent, which could be useful in cases like litigation that we've seen against the BLM, who included wildlife services and ecosystem services as part of their multi-use definition?
I think if the land remains in federal ownership, there's a good argument to be made that there is value in those services as wildlife habitat, as domestic watersheds, as scenic landscapes, whatever that might be. How that's quantified, how that's valued, and how that's turned into funds that land managers can spend on the ground, that's a harder question. I mean, it's easy to say, all right, the landscape outside of Moab is priceless, but then who's going to pay for it, right? I mean, I think there are very interesting questions about how we quantify the value of ecosystem services, whatever that might be. And I suspect, and I'm totally winging this, that it's probably easier to sell that value to Congress, to say, all right, national forests or whatever percentage of our drinking water comes from national forests. We therefore derive that value. We need to protect that. And that becomes kind of a policy driver. I think the state would probably recognize that same argument, but how they would quantify it and how they would fund that, I think that's just different. We're able to spread that land management cost here across 49 other states, right? I think it just becomes more challenging. I don't know if that answered your question at all.
Yeah, thanks.
Thanks. I have questions about accountability and responsibility. I don't know if you mentioned who's behind this, and also how much is it going to cost, and when, hopefully, the Supreme Court refuses to take it up, refuses to grant cert, will we see a full accounting and know how much each taxpayer paid for this folly?
Great question. I don't know who's behind this. I mean, obviously, the Attorney General, the Governor, the Speaker of the House, the President of the Senate, they all rolled out, the announcement that Utah had filed this lawsuit. I don't have any insight into who was sitting around the table deciding how to frame it, that this is the time that Paul Clement and his firm and his partners are the people to push this. I just don't know. In terms of how much we're spending, the reports I've seen are that the legislature has appropriated $2.6 million for public relations, so billboards and newspaper articles and so forth, that they've spent the majority of that, and they anticipate spending through that, early next year. But again, I mean, that's newspaper reports. My understanding is Sean Reyes, the Attorney General, made a statement about having $20 million to spend on the litigation. I don't know anything more about what that means, if that's $20 million in outside resources in addition to what the attorneys in the Attorney General's office or PLIPCO are spending. But like I say, Paul Clement's making $2,300 an hour. I mean, and he's a really good lawyer. That's not a surprising number, but I think it's worth considering, what the cost will be and how long this will go on into the future, how much it will cost. With that cost side of the equation in mind, is this the best way to solve our public land management problems? And, to be clear, I think we have real problems in the way our public lands are managed. We can have healthier landscapes. We can do a better job. I'm just not sure litigation gets us there.
Why wasn't this lawsuit something that was on a ballot or that the people had a voice in?
Because the legislature didn't pass a referendum and ask. I mean, it's a fair question, but there's no requirement for it. There's no requirement for the legislature to reach out and say, hey, how do you all feel about this? And whether the people in this room, whether we represent kind of the majority opinion, I don't know. It'd be an interesting debate, though, interesting discussion about whether this is the best use of, whether the outcome is what we want, whether this is a good use of our public funds, whether there are better ways to work with the federal government. I mean, I'm a former Fed, so I'm a little biased, but I don't think you can go around poking people in the eye, suing them all day, and then complain that they don't want to partner with you, right? It's just difficult. And we in Utah do a pretty good job of wagging a finger and yelling at the federal government. So it doesn't always get us that far.
We got one real quick. On the podcast that Caitlin did recently, there was some talk, and we've had some internal conversations in BHA Utah chapter about the Antiquities Act. And we see a lot of this is probably stemming from historical monument designations within Utah, the battle over Bears Ears, et cetera. With that kind of discussion that we've been having, from a legal perspective, what are the steps that would need to be taken to change the Antiquities Act or audit it to make it so that it takes into local land manager accounts a little bit better and provides some of the relief to the criticisms that Utah has?
It's a really interesting question. The Antiquities Act, 1906, It takes that congressional authority over public lands and it says, we, Congress, are going to grant some authority to the president to designate national monuments. Those monuments have to be on land that's owned or controlled by the federal government. They have to be designated around objects of historic or scientific interest, and the boundary has to be confined to the smallest area necessary to protect those lands and resources. That's it. That determination is up to the president. It's very different than a lot of other laws that empower agencies like the EPA or the Forest Service or the BLM to act. Because there they have processes they have to go through. Here, under the Antiquities Act, you simply have those requirements, and it's the president's discretion over whether the place, the objects, the resources are good enough. And there's a whole big, long behind-the-scenes process to make those determinations. But Congress could clarify the Antiquities Act. It's straightforward. Introduce a bill into the House or Senate, make sure it's passed in identical form in both chambers, signed into law by the president. If they wanted to say, for instance, there was an acreage limit, Congress could do that. There have been efforts to amend the Antiquities Act for years, and they've never gone anywhere. I think it's possible that we'll see something. I don't think it's particularly likely. And one of the things, back to hope, right? I'll try and do the hope thing again. I'm not really a ray of sunshine, but, and I think we talk about national monuments. Most Americans don't understand the difference between a national monument and a national park. All they know is they're cool. They want them. People love public lands. They love parks. They love monuments. I don't think there's a ton of political upside to passing legislation that undermines something like 85 or 90% of Americans think is a good idea. That doesn't feel like it's politically palatable. And if I was, advising a member of Congress or the administration, I'd be saying, maybe that's not the fight you want to take. But that's just me.
Do you think the Antiquities Act allows for a president to be able to rescind a monument?
No. I say that with a little bit of bias because I worked on some of the litigation challenging President Trump's reductions to Bears Ears and Grand Staircase. So it comes with that caveat. No, I don't. I think the Antiquities Act is a one-way valve. I think the language in there is very clear. It says the president has the authority to declare by public proclamation lands as national monuments. It never talks about undeclare. It never talks about unproclaim. I think if you go back and you look at other federal laws that deal with federal lands around that time, shortly before the Antiquities Act was passed and for years afterwards, Congress knew how to create a two-way valve. It knew how to say, presidents, you can reserve lands as national forests, and you can modify those later, or you can revoke those later. You can set aside lands for reclamation projects and reservoirs, and you can take those back later. The choice not to make it a two-way valve in the Antiquities Act, I think that has to be given effect. So I think just on its face, I don't think there is a particularly compelling argument, at least in my mind, for a president to reduce a national monument. And again, we're kind of going off on a tangent here, but all of those lawsuits are still alive. The lawsuits challenging the original Trump reductions, they're sitting in Judge Chutkan's chambers back in federal district court in the District of Columbia. So those cases are there. They're essentially on hold. The state of Utah challenged President Biden's reinstatement of Bears Ears. That case is pending before the 10th Circuit. I'm not sure procedurally what it would mean if incoming President Trump then undid Bears Ears again, because then people are going to sue over that. Procedurally, I don't know how. I need a whiteboard to untangle that. And again, I come back to I don't think it's good politics. I don't see the upside for President Trump.
Was there an injunction ever to stop this ranking?
No, to the best of my knowledge, there was not. The response was the Biden administration came in, reinstated the monument, protected all of the lands that had been previously protected. The state of Utah, if I recall, and there may be some others here that can speak to this better than I can, but my recollection is that the state of Utah moved to dismiss the case as moot at that point, and the Department of Justice, at the urging of some of the environmental plaintiffs, said, don't. You have to keep this case alive for super wonky reasons, right? So you think the monument's reinstated, that solves all your problems. That's, back to where you were, all is good. The problem is in that gap in time between the Trump reduction and the Biden reinstatement, there were a number of mining claims that were staked in both the Grand Staircase and in Bears Ears. The question becomes whether those claims were lawfully staked. If the monument was not lawfully reduced, then those mining claims were invalid from day one. If the reduction was lawful, then they still may be invalid claims, but we have to go through a very different process. So we got into this kind of nerdy argument about needing to understand the status of the reduction in order to understand the validity of a couple dozen mining claims. And I think it just kind of sat. I don't know, again, there may be others that know a little more about kind of the internal workings on that, but I think, not to speculate too much, but Judge Chutkan's had a lot on her plate over the last several years, and I don't think this just was one she really wanted to make front and center for.
So I have a two-part question for you. Can the general public make a difference in this case? And if it goes to Congress, can the general public make a difference? BHA and other organizations in Utah and across the country want to reach out to people, but this is a very complex thing as we're gathering right now. How do we reach those people? How do we get people to care about this enough to do something when it's so complex and so tangled? Great question.
I'm going to kind of take that in reverse order. The first thing I'd say is we need a good slogan. Public lands in public hands, something like that. Those things are great, right? Keep doing that. Because the state's very good at being like, take back our lands. They're very good at bumper sticker slogans. And when you put that out there, whether it's a bumper sticker or a tweet or whatever we call that now, an X or whatever that is now, it frames the debate, right? And then we end up with this kind of bizarre discussion on a Wednesday night in a museum talking about public land law and the Treaty of Guadalupe Hidalgo to try and unpack the fact that they're not our lands to take back, right? Thank you for coming out, but you're pretty extraordinary here. Most people don't want to do that. We need to figure out a way to message. We need to figure out a way to message clearly, concisely, and critically. And we need to be on the front foot, not the back foot. So in terms of the second part of your question, yes, I think we can make a huge difference in the halls of Congress. Because, I think most members of Congress, outside of kind of the rabble-rousing West, they don't see an upside in this. Unless it's a handful of people that are saying this is a source of revenue and it's our way to pay down a national debt. I think it's much easier to have that argument in Congress to say, look, these are your public lands. These are the places where you hunt, you fish, you recreate, you hike, you birdwatch. We're talking about Alta and Snowbird here, right? Frame it in ways that resonate with people. And I think people are going to say, wait a minute, I don't want that sold off to the highest bidder. I don't want that going to a hedge fund or to China. I want that right here. I want that for my kids. Now, the first part of the question, is there anything we can do about the lawsuit? Cat's out of the bag. Lawsuit's been filed. I don't think we're ever going to get Utah to say, oops, we take that back. I think we need to wait and see what the Supreme Court does. I hope the Supreme Court says we're not going to take up this case. Maybe wrong, but that's what I hope. If the Supreme Court says nope, file in a district court if you want to proceed, then I think we have an opportunity to go back to the governor, to the legislature, and say this is a bad idea. And I think we can start to ask some of these questions and point out that it's not well thought through. And maybe the argument is it's less about the environment, it's less about wildlife, it's less about public lands. I know that resonates with us, but I'm pretty cynical right now. I think there are a lot of folks in Congress and the legislature that aren't thinking about lands the way we do. If we can make arguments that maybe are more economic, if we can talk about cost, risk, uncertainty, we can talk about the opportunities that are foregone when you sue the federal government, if we can talk about the uncertainty that creates for users of public lands, whether it's us, whether that's livestock grazers, whether that's miners, whether that's, solar energy developers, whether that's people that are trying to produce the critical minerals to fuel the green transition, we can point to uncertainty and risk and the delay it causes. So
I'm going to jump in here. I think I would be remiss at this point not to mention that BHA has launched an initiative around Utah's lawsuit. It's utahisnotforsale.org. It's meant to act as a website apart from their backcountryhunters.org site. It's a clearinghouse for news and updates. There's Take Action. I only say that because I think as the issue continues to move through the channels that it will or won't, people are looking for real information in real time, and I think that's at least one source that we can turn people towards. Secondly, I want to be mindful of the museum staff's time, so we probably only have time for one or two more questions.
Can I just piggyback on that really quick? Talk to your neighbors, talk to your friends, talk to your family. Help them understand these issues. They're complicated. And even if the bottom line is, God, what a mess, that's an important message. And yes, reach out to your legislature, reach out to Congress, reach out to your elected representatives. And if you have a few minutes, write that note by hand. Because you know what? People get a lot of email. And if it looks like a form letter, it looks like a form email, it doesn't get the level of attention that, a handwritten letter does. So it doesn't need to be long, doesn't need to be complicated, but simply saying, hey, I'm a real live living human being, not a bot. I wrote this, I took the time. I think that gets through to people.
I want to piggyback off the piggyback real quick. All of us here live in Utah, and we understand what's at stake. I think the biggest thing is there's a lot of transplants in this room from places with less public land. So reach out to your families back east and in these coastal communities where they may not know what's at stake. I think this past June when my wife and I got married, my father came out and said, "You can hike up that mountain?" And I said, "Yeah, it's public land. We can just go do that." It was an eye-opening experience for him. So we know what we have to do in this room. We get it. It's those folks outside of Utah and outside of the West that we need to be really reaching out to, especially if this goes to the district court, because those stories of bringing their family out to Utah and recreating are really impactful. So,
any final takers?
Does it help to sign petitions and everything like that? Like numbers that way?
Yes and no. I think it's always helpful to show support. It's always, if you see a rulemaking decision, you go through that process, you're always going to see a disclosure about, we received 200,000 comments, 85% of which were in support, whatever. So it helps in that sense. It's going to help the decision maker hopefully feel like they have support for whatever that outcome might be. That said, they don't carry a ton of weight. The honest, no BS answer about how federal rulemaking works, and I'm sure it's the same at the state level. You're working on these massive rules. You've got 200,000 comments. There's an outside contractor that's hired to manage this process. They give you a report. The report kind of goes through these summary statistics. Every comment is scanned. Everything is in a computer. You can look at it. But petitions look the same. Postcards look the same. Once I've read the first one, I don't have to read the next 1,000. What happens as a no BS reality is that the written comments get kind of binned. The agency knows who is going to sue them. They know who has put a lot of hard work into comments. So those comments, they kind of rise to the top and they get read repeatedly. The ones that come in from well-known experts, they get read. The ones that come in from, big organizations like BHA, they get read. So if you're really trying to influence the process and here I'm thinking of kind of massive federal rulemaking processes like the Public Lands Rule or the NEPA regs, but sign the petition, but then if you can, take a few minutes and write your own comment.
John, I want to thank you so much for your time. I want to thank you not just for your time tonight, but the thoughtfulness that you've brought to this issue for over a decade now, well over a decade. And if I were to turn the question back onto myself, what gives me hope? I think my hope really, truly is to know there are real, knowledgeable, thoughtful advocates for public lands working actively behind the scenes and in front of the scenes, and knowing that we're not alone in this effort, because as volunteer advocates, it's easy to lose sight of the end game. It's easy to get discouraged. And I think your talk tonight is hopeful, for me at least, to know that somebody is putting as much time and care into this issue as you are. How can people keep up with you? How can they find some of your work or some of the things that you'll surely have to say as the suit advances or doesn't advance?
I guess first, please continue to stay involved, continue to stay engaged. So that's the takeaway. If you want to track me or contact me, my email, I think it's on the announcement that went out. So feel free to email me. It's john.ruple@law.utah.edu. And you should be able to find me off the university webpage and the Stegner Center stuff. And if not, I'm sure Josh and others can help track me down. So I'm happy to continue the conversation. We do have some information on the Stegner Center webpage, but it's buried. It's hard to find. Send me an email. I'll point it out. There is, if you're really bored or you just can't sleep, there's an article in the Colorado Journal, their Natural Resources and Environmental Law Journal, I think from 2018, that I wrote, that went through and critiqued all of these arguments on the Transfer of Public Lands Act. It's free. If you can find it, it's there. We also have some white papers that were published on the Stegner Center webpage that are a little more digestible. There are 5 to 10 pages that go into some of the questions here about how did federal government come to own land? What are the legal obligations to manage it? What are the legal questions around disposal? What are the policy implications? That stuff's a little dated at this point, but it's still largely relevant. Since, frankly, the state's recycling a lot of the same arguments. So those things are there. I'm happy to share those with you if we can. I will say there is an effort to update those and put out a little more, kind of an updated piece that goes directly at the state's legal claims here, that the Constitution doesn't allow the federal government to own land. We've been trying to do that in concert with a number of other universities across the West, in part because, frankly, I'm a state employee and I don't have a bullseye on my back. But I think this is more than just a Utah issue. I think it's important for legislators around the West to understand this is Wyoming, Montana, Idaho, Utah, Colorado, Washington, Oregon, Arizona. The arguments that are being made in front of the Supreme Court impact all of the West, and they impact all of the United States. So hopefully we'll be able to get those things out, but frankly, there's so many things on the plate, it just hasn't percolated up yet.
Yeah, great. Caitlin, is there anything we need to know before we take off tonight?
Nope, we will send out a link to all RSVP guests that has links to an email that has links to John's work and references made tonight. So be on the lookout for that.
Yeah. And with that, can we all please give our guest a round of applause?